Judge Andrew Napolitano believed he could quiet Congresswoman Jasmine Crockett by issuing a $1,000 contempt fine during her testimony. At 75, the former Fox News legal analyst, now a federal judge, sat before her with full confidence in his authority, unaware of what was about to unfold. "You're out of order, Congresswoman," Napolitano declared, his voice carrying across the crowded courtroom. "I'm finding you $1,000 in contempt of court." The room went silent. Crockett, once a civil rights attorney, slowly stood. What she said next didn't just surprise those present. It raised serious questions about the moment. But before we continue, stay with the story as it develops. That morning, the federal courthouse in Washington, D.C. felt tense. Just weeks earlier, several states had passed new voting laws that civil rights advocates criticized as some of the strictest in recent years. What was expected to be a standard expert hearing on voting rights had turned into a heated political exchange. For years, Napolitano had been a well-known legal analyst on Fox News, recognized for his firm tone and detailed discussions of constitutional law. His commentaries built a strong following among viewers who valued his focus on legal principles. When he was nominated to the federal bench, it seemed like a natural step in a career shaped by a clear legal philosophy. Even his Senate confirmation proceeded without major resistance, with some Democrats acknowledging his expertise. Colleagues often described him as careful and highly confident in his reasoning. The hearing that brought him face-to-face with Crockett focused on the Protecting Voting Rights Act, a bill intended to restore key provisions of the Voting Rights Act that had previously been limited by the Supreme Court. Crockett was invited to testify about voting conditions in Texas. She arrived with a detailed binder containing documentation she said showed how certain policies affected voter access. For Napolitano, it was expected to be routine: ask questions, maintain order, and guide the discussion. The session began just as he anticipated. Seated behind the bench, he looked down at Crockett, who remained calm at the witness table. "Congresswoman Crockett," Napolitano began in a steady tone, "you've made serious claims about voting restrictions in Texas. I trust you have clear evidence to support them." Crockett met his gaze, composed and focused. "Your Honor, I have extensive documentation indicating voting access challenges affecting more than 200,000 individuals in my district alone." "I will determine what qualifies as evidence in this courtroom," Napolitano interrupted, his voice tightening. "Please keep your remarks focused on facts, not political commentary." Crockett's expression sharpened slightly, but she remained steady as she opened her binder. "Of course, Your Honor. Let's begin with documented instances of polling locations being closed without notice, many of them in historically underserved communities." As she continued, something shifted. Her testimony was not rhetorical, it reflected a structured legal argument. She referenced statutes, data, and documented findings with precision. "In Harris County alone," Crockett continued, "we identified 147 polling place closures between 2020 and 2024, with a significant portion occurring in minority neighborhoods." "Congresswoman," Napolitano interjected again, "correlation does not prove causation. You cannot assume intent." "I'm not assuming intent, Your Honor," Crockett replied firmly. "I'm presenting statistical data supported by internal communications from state election officials obtained through Freedom of Information Act requests." The atmosphere in the room grew more intense. Some attendees shifted in their seats, while others leaned forward, recognizing the weight of her remarks. Napolitano's expression tightened. He was not accustomed to witnesses, especially public officials, being this methodical and prepared. Crockett continued, "We also have documentation suggesting these closures followed a broader pattern." "That's enough," Napolitano said sharply, his voice echoing through the courtroom. "Congresswoman, this is not a political forum. I asked for facts, not speculation." The tension was unmistakable. Crockett closed her binder carefully and looked up. Her voice remained calm but firm. "Your Honor, every point I've presented can be verified. If there are concerns about the information, they can be addressed directly." A quiet murmur spread through the room. Reporters took notes quickly, sensing the significance of the exchange. Napolitano's expression hardened. A sitting congresswoman had just challenged his position in open court. "Congresswoman Crockett," he said, his tone controlled but firm. "You seem to forget this is a federal courtroom, not the House chamber. I will not accept your tone." Crockett stood fully upright. "Your Honor, I have remained professional. I've presented factual evidence. If the truth feels disrespectful, perhaps the issue lies in how it is being received." The silence in the room was complete. Even the court reporter paused, waiting. I will ask you once more, Napolitano said, his voice tight with controlled frustration. Limit your testimony to evidence. No commentary. Everything I've stated is evidence, Crockett replied steadily. The internal emails showing coordination to close polling sites, evidence. The statistical analysis indicating disproportionate impact, evidence. The sworn statements from affected voters, evidence. Which of these, Your Honor, would you like me to leave out? At that moment, Napolitano made a decision that defined the exchange. Instead of addressing her legal argument, he relied on his authority. Congresswoman Crockett, he said, raising his gavel, you are out of order. I am holding you in contempt and issuing a $1,000 fine. The sound of the gavel echoed through the courtroom. For a brief moment, no one moved. A federal judge had just fined a sitting congresswoman during testimony on voting access. Then something unexpected happened. Rather than stepping back, Jasmine Crockett showed a calm, composed expression. As the gavel struck, the atmosphere in the courtroom shifted. What was meant to end her testimony instead opened a more complex legal exchange. Your Honor, Crockett began, her voice calm but firm, drawing the room's full attention, I acknowledge your ruling. However, before we proceed, I have a few questions regarding the legal basis of your decision. Napolitano raised an eyebrow. Congresswoman, you do not have the authority to question my rulings in this courtroom. With respect, Your Honor, I do, Crockett replied in a steady and professional tone. As a member of Congress, protected under the speech or debate clause, and as a licensed attorney, I have both the right and the responsibility to address any ruling that may raise constitutional concerns. A quiet murmur spread through the courtroom. Some attendees reached for their phones, while others leaned forward, recognizing the importance of the moment. The speech or debate clause, found in Article 1, Section 6 of the U.S. Constitution, protects members of Congress from being questioned elsewhere regarding their legislative activities. Crockett continued, my testimony today relates to pending voting rights legislation, which falls within that protection. As a result, the contempt ruling may raise concerns regarding the separation of powers. Napolitano looked at her closely, processing her argument. This was not simply a political response. It was a structured legal position presented with precision. Furthermore, Your Honor, Crockett continued as she opened her folder, before issuing this ruling, did you consider your own prior public statements regarding voting rights legislation? She paused briefly, then continued. Specifically, your comment made on Fox News 3 weeks ago, where you stated that the Protecting Voting Rights Act represented constitutional overreach. Did you make that statement? The room reacted immediately. Some appeared surprised, others concerned. Reporters began typing quickly. My previous commentary as a private citizen does not affect my judicial responsibilities, Napolitano responded, though his tone showed some strain. Doesn't it? Crockett replied. The Judicial Code of Conduct, Canon 2, requires judges to avoid even the appearance of impropriety. Publicly expressing strong views on legislation, and then presiding over related matters, may create that appearance. She paused briefly, allowing her words to settle before continuing. In addition, Your Honor, were there not concerns raised by ethics experts during your confirmation regarding potential conflicts related to your media appearances? That point alone carried weight, but Crockett continued. There is one more matter, she said, reaching into her briefcase and taking out a tablet. Are you familiar with the law firm Brennan and Associates? For the first time, Napolitano's composure appeared unsettled. Congresswoman, I fail to see the relevance, he responded. It is relevant, Crockett replied evenly, because Brennan and Associates has reportedly received significant funding in recent years to challenge voting rights legislation in federal courts. According to your financial disclosures, you hold a notable investment in that firm. The courtroom quickly grew louder. Some raised objections, while others called for clarification. The media section became increasingly active. That is incorrect, Napolitano said, his composure beginning to slip. Crockett lifted the tablet slightly. These documents are based on your official financial disclosures filed with the Administrative Office of the U.S. Courts. Line 47 clearly lists your investment in Brennan and Associates. Would you like me to read the amount? She asked, looking directly at him. $847,000 in stock, Your Honor. Nearly $1 million invested in a firm that benefits from opposing the very legislation I am here to defend. The silence that followed was striking. Crockett had not only defended her position, she had raised concerns about a potential ethical issue that directly affected Napolitano's credibility. Your Honor, she continued calmly, I formally request that you recuse yourself from any proceedings related to voting rights legislation due to a clear conflict of interest. I also move that my contempt citation be dismissed as constitutionally invalid and ethically questionable. The judge, who had appeared confident moments earlier, now sat still, his authority visibly challenged. "Court is in recess," he said quietly before stepping away from the bench. As Napolitano exited through the side door, the courtroom grew loud with discussion. Yet amid the reaction, Jasmine Crockett remained composed, having just delivered a significant legal challenge. The response was immediate. Within hours, several lawmakers called for further review of Napolitano's actions. Advocacy groups focused on voting rights also began to reference the moment as part of a broader discussion about judicial conduct. The White House faced questions and was asked to comment on the situation involving a judge appointed by a previous administration. Meanwhile, the Judicial Ethics Committee announced it would move forward quickly in reviewing related complaints. Behind the scenes, additional reviews were reportedly initiated. Congressional committees began examining financial disclosures, and early inquiries into possible judicial conduct concerns were discussed. Crockett's exchange did more than challenge a single ruling. It brought attention to the broader relationship between legal decisions, financial interests, and public trust. It also highlighted how legal arguments can shape complex institutional discussions. Rather than focusing only on the contempt citation, Crockett emphasized constitutional principles and accountability. Her approach reflected a structured and informed legal strategy within a highly visible setting. What are your thoughts on this situation? Share your perspective in the comments below. If you found this discussion insightful, consider subscribing for more in-depth stories and analysis. Instead of recognizing that he was facing a legal argument presented with equal precision, Judge Napolitano relied on the authority of his position. "Congresswoman Crockett," he said, raising his gavel, "you are out of order. I am holding you in contempt and issuing a $1,000 fine." The sound of the gavel echoed through the courtroom. For a moment, everyone remained still. A federal judge had just declared a sitting congresswoman in contempt during testimony on voting access. Then something unexpected occurred. Rather than stepping back, Jasmine Crockett maintained a calm, confident expression. As the gavel came down, the tone in the courtroom shifted. What was expected to end her testimony instead marked a turning point in the exchange. "Your Honor," Crockett began, her voice steady and controlled, drawing the room's attention, "I accept your contempt ruling. However, before we proceed, I would like to ask a few questions about the legal basis of your decision." Napolitano raised his eyebrows. "Congresswoman, you do not have the authority to question my rulings in this courtroom." "With respect, Your Honor, I do," Crockett replied. "As a member of Congress protected under the speech or debate clause, and as a licensed attorney, I have both the right and the responsibility to challenge actions that may conflict with constitutional principles." A low murmur spread through the courtroom. Some attendees reached for their phones, while others leaned forward, aware that the moment carried importance. The speech or debate clause, Article 1, Section 6 of the Constitution, protects members of Congress from being questioned elsewhere about their legislative speech, Crockett continued. "My testimony today concerns voting rights legislation currently under review. That places it within that protection. Therefore, your contempt ruling may raise concerns regarding the separation of powers." Napolitano watched closely, considering her argument. This was not a general political response. It was a detailed constitutional position. "However, Your Honor," she continued, opening her folder and reviewing her documents, "there is another issue to address. Before issuing your ruling, did you take into account your own public comments regarding voting rights legislation?" She paused briefly before continuing. "Specifically, your appearance on Fox News 3 weeks ago, where you stated that the Protecting Voting Rights Act represented constitutional overreach. Did you make that statement?" The room reacted immediately. Some appeared surprised, while others showed concern. Reporters began typing quickly. "My previous remarks as a private citizen do not affect my judicial responsibilities," Napolitano replied, attempting to maintain composure. "Do they not?" Crockett responded. "Under the Judicial Code of Conduct, Canon 2, judges are expected to avoid even the appearance of impropriety. Publicly criticizing legislation and then penalizing a congresswoman for defending it may create that appearance." She paused briefly, allowing her words to settle. "In addition, Your Honor, were you not advised by judicial ethics experts during your confirmation process that your media appearances could raise concerns about impartiality?" The constitutional argument alone carried weight, but the discussion that followed placed even greater focus on questions of credibility. "Your Honor, there is one more matter," Crockett said, reaching into her briefcase and taking out a tablet. "Are you familiar with the law firm Brennan and Associates?" For the first time during the hearing, Napolitano's expression shifted. "Congresswoman, I fail to see how that is relevant." "It is highly relevant," Crockett replied calmly. "Brennan and Associates has received between $2 and $3 million from the Republican National Committee over the past 2 years to challenge voting rights laws in federal courts. According to your own financial disclosures, you hold a significant amount of stock in that firm." The courtroom reacted immediately. Some members stood to object, others called for clarification, and reporters moved quickly to capture the moment. "That is incorrect," Napolitano said, his composure beginning to falter. Crockett raised the tablet, displaying the documents. "These are your official financial disclosure forms filed last year with the Administrative Office of the U.S. Courts. Line 47 lists your investment in Brennan and Associates. Would you like me to read the exact amount?" She glanced down briefly. $847,000 in stock, Your Honor. Nearly $1 million invested in a firm whose primary work involves opposing the legislation I am here to support." A deep silence followed. Crockett had not only responded to the ruling, she had raised a serious question about potential ethical conflict in open court. "Your Honor," she continued, maintaining a steady tone, "I respectfully request that you recuse yourself from any further proceedings involving voting rights legislation due to a clear conflict of interest. I also request that my contempt citation be vacated as constitutionally and ethically invalid." The judge, who had appeared confident earlier, now sat still, his authority under visible strain. "Court is in recess," Napolitano said quietly before stepping away from the bench. As he exited, the courtroom filled with noise and discussion. Yet amid the reaction, Jasmine Crockett remained composed, standing calmly at the witness table after delivering a detailed legal response. The response beyond the courtroom was immediate. Within hours, several political leaders called for further review of Napolitano's actions. Advocacy groups focused on voting rights began referencing the moment as part of broader concerns about judicial conduct. The White House faced questions and was asked to comment on the situation involving a judge appointed by a previous administration. At the same time, the Judicial Ethics Committee announced it would accelerate its review of related complaints. Behind the scenes, additional steps were reportedly taken. Congressional committees requested access to financial records, while early inquiries into possible judicial conduct issues were discussed. Crockett's exchange did more than challenge a single ruling. It brought attention to the relationship between financial interests, legal decisions, and public trust. It also highlighted how preparation and legal knowledge can influence high-level proceedings. Her response focused on constitutional principles and accountability, offering a structured legal argument in a highly visible setting. What are your thoughts on this situation? Share your perspective in the comments below. If you found this discussion useful, consider subscribing for more in-depth stories and analysis. What was not immediately visible to the public was the level of activity taking place behind the scenes. Congressional investigators began reviewing Judge Napolitano's financial disclosures, while reports indicated that a preliminary inquiry into judicial conduct had been considered. The courtroom exchange brought attention to a broader network of legal and financial relationships connected to voting rights cases. It suggested that legal outcomes can be influenced by multiple factors, including institutional and financial interests. At the same time, the moment demonstrated that established systems can be examined through careful preparation, clear reasoning, and adherence to legal standards. Jasmine Crockett did not simply respond to a contempt ruling. She presented a detailed argument that emphasized accountability and the role of constitutional protections in modern governance. Her approach reflected a model of structured and principled engagement within the legal and political process. What is your view on this case? We invite you to share your thoughts. If this story was informative, consider subscribing for more content that explores complex issues with clarity and balance. Napolitano, visibly unsettled, quietly said, "Court is in recess," and stepped away from the bench. The response was immediate. Several Democratic leaders called for his impeachment. Advocacy groups began to organize, and the Judicial Ethics Committee moved forward with an accelerated review. What started as an effort to silence a congresswoman ultimately became a significant moment in the broader discussion of judicial accountability.